Good afternoon, everyone. My name is Baldev Binder. Welcome to our webinar today on the options available when looking to appoint a receiver, liquidator, or apply for a freezing injunction. I have today a great panel. I have of old friend Andrew Stevens from Palm Court, who's a barrister in the UK, doing a lot of Asia-based work. I have Mr. Luke Fuller, who is from AJ Capital Advisory, who is, for our benefit, both a receiver and a liquidator in terms of appointments. So there's real practical experience that both these gentlemen will share with us. I will start today's session with giving a brief overview of what I think is a strategy map or a game plan when it comes to what the options are. But before I do so, let's set the context for where we are when coming to decide what I effectively call the 10-point enforcement strategy, which I put up on the screen over here. So the situation is this, and I don't think the situation is uncommon. Last year would have shown a lot of situations of this nature, and I think it will go on for the years, for this year and the year after as well. The situation is a situation of debt enforcement. It is a claim being brought by either a lender or as a counterpart trader against a debtor who hasn't paid. And in this time when the debtor is negotiating, the debtor might tell the creditor, no, I haven't got enough funds, I need more time, COVID is impacting me. Then there's often a tipping point, and that tipping point tends to be either other creditors pursuing the debts or revelations of dishonesty or dissipation. When this happens, as a creditor, it is a very intense period of finding out what the situation is, where the assets are, and what to do next. And that is where real clarity of mind is imperative. And I've set forward what I think is a 10-point enforcement strategy to consider in any enforcement exercise to consider, because each enforcement strategy, each consideration will inform your enforcement strategy. So the options, broadly speaking, are these. In a situation where there is debt enforcement, the options are: do you appoint a receiver over the assets covered by your contract, by your facility, for example? Do you apply for judicial management? Do you put your debtor into judicial management? Thirdly, do you liquidate the company and apply for liquidation? And the fourth is what we use the term freezer, but it's meant to cover a freezing injunction that freezes, we use the term loosely, freezes the assets, but I'll come to it in a second. Luke is going to speak in greater detail about the differences between receivers and liquidators and what your options are and when each appointment is better. Andrew is going to speak specifically about freezing injunctions and the practical considerations to consider before launching what we call the atomic weapon in law. For my purpose, I'm giving the broad overview of the different options. And let's start right from the top. When is it appropriate to appoint a receiver or a JM, liquidator, or a freezer? And the options are pretty much dictated by what the situation is. If, for example, there is a contractual right to appoint a receiver, if you've got an asset that has got rights of receivership over it, then that could be a possible option. If you're looking to resuscitate the company and there's impropriety on the part of directors, in the sense that you might have spotted some of the directors dealing in assets unconscionably or not running the business properly, then judicial management might be a way of stepping in, resuscitating the company, understanding its affairs, and perhaps drawing on a restructuring. The third option will then be: when is liquidation appropriate? And that's a very obvious answer: when the debtor is unable to pay its debts. And the last, the freezing injunction, is when the threshold question that is often asked by any lawyer when you ask them to get a freezing injunction is, has there been dissipation of assets? Now, that's a broad term, and I think Andrew will speak to details as to what really is dissipation and what can be considered dissipation. The point about the freezing injunction to take note over here is that it is a means to an end. It is not the end by itself. You still need to get a judgment. The freezing injunction freezes the ability of the debtor to deal with his assets for the purposes of securing enforcement by way of a judgment. So it's a means to an end. The second point to consider would be this: information. It's good and easy to sort of plan out an enforcement plan, but information in these sort of situations tend to be limited, they tend to be opaque, and for most times you're relying on the director to give you information on where the assets are. So for a receiver, for example, that tends to be fairly self-contained. A receiver tends to be appointed over a specific asset, and that should be fairly visible. When it comes to judicial management or liquidation, on the other hand, you're pretty much in the hands of the directors. So the liquidator and the JM goes in looking at the assets of the company, but they are still third parties, and they're very much relying on the directors to give them a statement of affairs to show what the state of play is in the company. Freezing injunctions are one of the few times, not the few times, I think it would be imperative with a freezing injunction to go get an investigator. Most of the times there is some notion, some suspicion of assets being dissipated, but without getting an investigator, it is extremely difficult, because a freezing injunction really is obtained with one hand or one eye on enforcement and effectiveness. And enforcement and effectiveness really turns on where the assets are. So investigators are key in a freezing injunction. We then go to type of asset, and I don't think there's much to be considered over here. Naturally, where assets are fixed, that are easier to deal with for parties. I want to stress the point on receivables, because a large part of any debtor's assets tends to be their receivables, and that's a murky concept. What are receivables and whether they're truly good for its dollar value, it's notoriously difficult to figure out. Receivables from debtors in the Middle East, from India, from parts of China, there has to be a fair amount of discount being applied towards that sort of receivables in terms of getting actual monetary value from it. To jump on the type of asset, I think when it comes to a freezing injunction, we have to remember you're not really freezing the asset. The injunction is an injunction against the person, against the debtor, against the company from dealing with the asset, and for third parties who are holding the assets on behalf of the debtor, much like banks who are holding money on behalf of the debtor. The key point in all of this, I think, is the next one, which has to do with enforceability and effectiveness. And if you forget everything that I'm going to talk about today, just focus on this. Whatever you do, it has to be effective. For it to be effective, it has to be enforceable. And the considerations you have to ask yourself there are, where are the assets located? It is well and proper to get a freezing injunction in the UK or in Singapore, but if the assets are located in Africa, in parts of South Asia, how easy is it to enforce these assets? The next question you have to ask yourself is, who controls these assets? Is it a ship? Is there a third-party operator of these assets that you need to convince that you are now taking charge of? How easy will it be to convince this operator to give you possession of the asset? It's one thing to get contractual right over the asset, but another to get possession over it. Most times you need some sort of local enforcement in the jurisdiction where you're seeking to get the asset. So you get a UK court order, but you still need to go to the Indian courts to get it recognized. And that is, in my mind, I'm sure Andrew will have a different view about this, but in my mind, it's one of the drawbacks of a freezing injunction. in theory, it sounds incredible. You get a freezing injunction, it is worldwide, you get to freeze assets all across the world. But in practice, when you go to jurisdictions in the Middle East, in South Asia again as well, or for most countries as well, there is a challenge as to whether the local courts there will recognize a foreign freezing injunction. Sometimes they do because they are, reciprocal rules between the different countries. But for most parts, where assets are in challenging jurisdictions, you probably need to get a new freezing injunction in the local court. That means twice the amount of work. It means going through the dangers and the quirks of the local court system, and that really needs to be considered before launching a freezing injunction. But is that all doom and gloom with the freezing injunction in terms of enforceability? I would suggest not, because I think in large part a freezing injunction also produces voluntary compliance. You're looking at someone complying simply because of the threat of its assets being, not the threat, the control that its assets are now being frozen. So you're looking at voluntary compliance, and I say this particularly with banks. Banks may be based in the Middle East, they may be based in China, they may be based in Vietnam, and yes, they might not, strictly speaking, have to comply with a Singapore court order for that matter. But these large organizations like banks are fairly international in nature, and they would have branches in other parts of the world, and so they wouldn't want to risk being in breach. Even though it's a Vietnamese branch of a bank, they wouldn't want to risk to be in breach of a UK court order or a Singapore court order for that matter. The fifth point that I want to talk about then would be the notion of priority. When we're looking to get enforcement and we're considering the different options, I think one has to bear in mind that when pursuing judicial management or liquidation, it's effectively pursuing for the benefit of all creditors. Most creditors that launch this would be unsecured creditors. They would have to share whatever assets are obtained in a pari passu treatment, and that means an equal treatment between unsecured creditors. In a receiver sort of context, yes, you appoint a receiver over a specific asset. That asset, typically, depending on how it's contractually drafted, would be encumbered specifically for you. So there's an exclusivity over that. There's priority. For freezing injunctions, there is no priority. It is a freezing injunction achieves a lot of pressure on the other party, but it doesn't give you a priority. Let me explain this briefly. By getting a freezing injunction, there's every possibility of shocking the debtor to the point that the debtor says, okay, my business has come to a stop because I can't do all these different things. My banks can't, operate. So let me pay you your claim, and I want you to lift the freezing injunction. That is what most parties hope to obtain from a freezing injunction. It's a quick in and a quick out, but there is no priority in the sense that once the assets are frozen, they're not frozen just for you as the applicant of the freezing injunction. They are frozen until you get a judgment. So then there is a question of how quick you can get a judgment to enforce those assets. Now, bear in mind, if you get the judgment, if you spend 6 months or a year trying to get a judgment, and in the meantime another creditor applies for liquidation, then I think you might have the carpet pulled from under your feet. I've got a few minutes left on my speaking session, so I'm going to briefly run through more of the practicalities. And these tend to do with timing and with costs. I'm going to start with powers at the top of the slide. And powers have to do with, powers can be both contractual and statutory at the same time. A receiver has contractual powers that are contained within the document empowering the receiver to be a receiver. And that would contain rights, fairly broad powers, I would imagine, typically including rights of sale. In a judicial management and in a liquidation, you have extremely wide powers. And the one key thing about judicial management and liquidation is the ability to look back at past transactions and claw back transactions that were at an undervalue or for an unfair preference. In a freezing injunction, there is real bite with the freezing injunction because it leads up to a situation of contempt. A freezing injunction is an order not to dispose assets unless in the ordinary course of business, and any breach of that order opens up a debtor or a third party for contempt proceedings, and these are quite severe proceedings. In terms of speed, I've used the word fast and moderate throughout, and I am going to breeze through it quite quickly as well. It's hard to say how fast you can get this different appointments in place. I would say a receiver tends to be quite quick because you've only got your one consideration and your one arrangement to make with the receiver. With a freezing injunction, because of the preparatory work, you need to get all your ducks in a line before launching this atomic weapon. And that's why it might take longer. The process of actually getting the freezing injunction it can be a matter of hours or days as well, depending on how urgent the need is. Liquidation, on the other hand, there tends to be certain procedural steps that need to be taken, maybe 3 weeks for statutory demand before you can apply for liquidation. Likewise, for judicial management, I think it can be done fairly quickly. The remaining points about funding and costs, I'm going to do the two of them together. Funding and costs, it's an issue that you need to consider, because if you are taking on this burden of enforcement, the benefit might have to be shared, then you need to weigh up the cost of doing it and the benefit that you're going to obtain from it. In the case of a receiver, I leave it to Luke to explain in greater detail, but I think arrangements, typically a receiver will want some amount of money from the applicant before being appointed a receiver. When it comes to JMs and liquidation, I think there's a bit more flexibility in terms of these two appointment holders being able to take the cost of their work from the assets of the company. In a freezing injunction, this is typically I wouldn't say typically, this is always borne by the creditor. So the creditor takes out the freezing injunction, bears the cost. But as I mentioned before, it bears the cost to freeze the assets. That doesn't give priority to that creditor who takes it out. I've put risk on right at the bottom of the screen, and that is to cover the different risks that different appointment holders will have to take on. A receiver, naturally, it might have operational costs if it takes over a company, if it takes over an operating asset, for example. When it comes to the liquidation scenario, there is the risk considering what other creditors might want to do. And in a freezing injunction, I think there's always the risk of the applicant being accused of not giving full and frank disclosure of all material facts before obtaining the freezing injunction. I'm conscious I've breezed through this in a record amount of time. I am going to hand over the floor to Luke in the next minute or so. If there are any questions, I'm more than happy to take it towards the end. We've got 15 minutes at the end of this, at the end of the webinar to take questions. Very happy to have it before you, but this is the game plan to set the tone for the rest of the webinar. Luke, over to you.
Thanks, Baldev. Hi, everybody. You can see I'm bookended by two much more eloquent gentlemen than myself, two lawyers. As Baldev said in introduction, I am a liquidator, receiver, judicial manager, scheme manager in Singapore. So I thought I would, rather than repeat much of what Baldev has introduced, give a bit of a practical overview of the different options and appointments and considerations certainly from our point of view as a practitioner when clients come to us, either lawyers directly or funders and creditors, or the companies themselves that are perhaps taking money from some of the creditors on the call. So initially, I thought it might be useful just to give a very high-level overview of what is meant by these different terms, because we often get called by potential clients saying, I want to appoint you as a receiver. And after a little bit of investigation, I think what they really mean is we want to appoint you as a liquidator, and vice versa. They say we want to appoint you as a liquidator, and what they really mean might be a receiver or a judicial manager, or they might want you to help restructure the company. So very briefly, a liquidator, as I like to describe it, a liquidator or a liquidation is terminal. The result of a liquidation is the company will die. It will cease to exist. You know, a liquidator is fairly heavy-handed. It has very wide-ranging powers, like Baldev had mentioned. A lot of those powers are well suited to investigations, to claw back assets, to unwind transactions, and to really chase down or right wrongdoings. Or in the case of a company that has just failed because the business is no longer viable, to wrap things up and tie a bow in them. Importantly, a liquidation or a liquidator has a very limited ability to continue to trade a company. So if there is a trading company that to realize the value of assets, if they're receivables, so if you have a physical commodity business where there are goods floating out there in the ether, and a liquidate, and somebody needs to take control to make sure those voyagers' journeys are completed, then often a liquidator isn't appropriate if a liquidator is to take control, because that will stop the music and that might stop assets from being realized. Conversely, a receiver, as Baldev has mentioned, and I won't go into it too much, a receiver is really an agent on behalf of a creditor to get a specific job done. In this jurisdiction, Singapore jurisdiction, a receiver goes in to realize a specific asset for the benefit of the person that put them in, and then they walk away and leave the rest of the company or the mess to somebody else. In other jurisdictions, you have a receiver and manager. In Singapore, that's very similar to what we call a judicial manager here. So a judicial manager has a lot of the same powers as a liquidator that I mentioned, but a judicial manager will displace management. So when would you use a judicial manager? If the management has breached trust, done something wrong, no longer capable to run the company, have disappeared, or there's some form of conflict, then a judicial manager is appropriate because they step in, they effectively operate as the company, as the board of directors, and they can operate, they can trade, they can raise debt, they can sell assets, they can investigate and do a lot of the same things as a liquidator. Important difference is they can carry on the business. And then the last one I think is worth mentioning is, what is a scheme of arrangement? Because we see a lot of these at the moment in Singapore in the commodity space. Very different to the two or the three I've just mentioned. They're all creditor solutions. Liquidator, primarily driven by creditors, and if it's driven by the company, it's for the benefit of creditors. Receiver by creditors. Judicial management, again, can be driven by the company, but for the benefit of creditors. That scheme of arrangement is a debtor in possession. It's similar to, say, a Chapter 11 in the US or a creditor's voluntary arrangement in the UK. The scheme is typically initiated by the company as a way to restructure and compromise its debts. Now, why is that important to people on the line that might be from the credit side? Is because we see this a lot, particularly in Singapore, of companies putting the white flag up under a scheme of arrangement. They get protection from the courts, prevent enforcement. So they'll prevent creditors from being able to initiate a liquidation or appoint a receiver or appoint a judicial manager. And they will use that time to try and restructure the company. A slightly more sinister version of myself might say they might use that time to cover up some of their wrongdoings. It is important for creditors to be aware of the difference in these and what is their appropriate course of action, in each scenario. So from that, the key things, and Baldev has touched on a lot of these, but from a very practical point of view, when we're looking at a situation for a varying array of different clients, the questions we typically ask in a commodity context is, are the borrowers responsive? It's usually the first question we ask. Are the directors still around? Are the people who you had a relationship with still answering your calls and your emails? And that sounds like a pretty basic question, but more than 50% of the time the answer is no. So if they're not around, who is going to get access to the information, particularly, say, in a commodity finance trade? Who is going to help you get various pieces of paperwork, and in particular, who is going to help you lodge insurance claims in the event that you might have your credit insured? If the directors aren't there and you don't have access to that information, it's very difficult to get everything together to lodge your insurance claims. The second is, where are you getting your recovery? If you're a receiver, if you're secured over the receivables only, and that's your sole source of recovery, as Baldev mentioned before, could be troublesome. And I'll go through a few examples later. But if that is the case, what are the other sources of recovery? And we usually ask, is there insurance? Is there plant and equipment? Are there buildings? Does the sponsor or the borrower have houses? Are they personally wealthy? Is it worth doing some investigations to see where other recoveries might come from? Even if you are secured over the receivables, if it becomes clear that is not a very good claim because of a number of other events, maybe a better option is to force the company into a liquidation where you are simply an unsecured creditor, as Baldev mentioned before, but getting something from nothing is better than getting everything of nothing in the case of your receivables not being worth anything. So if, in the case if the assets are property, plant and equipment, personal assets, then you might want to rethink your enforcement strategy. The last couple, and Baldev touched on them, so I'm only going to do it very quickly, are where are the assets? If you appoint a receiver in Singapore and all the assets are in India, it's not going to be very effective. If all of the assets are in Singapore and that might be property assets, then great, the receiver is going to be very effective. But recognition is always very important. A lot of the jurisdictions, for example, Vietnam, Indonesia, Thailand, the Middle East, mainland China, are not going to recognise many of the orders of a Singapore court. So in that case, what we've helped clients with before is we may appoint receivers in Singapore over companies and over shares, and then we will replace the boards of directors at various subsidiaries as we move through the corporate structure, and we'll take control of companies as directors. And then as directors, we can then either initiate onshore proceedings or we can get into the company and get access to records. The last is funding. Who's paying? You want to make sure if you're paying, you're getting some form of priority for that. And again, if you're funding a receiver, it typically is capitalized on the cost of enforcement. If you're funding a liquidator, you want to get something in place to make sure you can sit at the top of the tree in terms of recoveries from the liquidation. But I suppose the key point I'm driving there is, what are the assets? Where are they? Really, where are you getting your money? As Baldev pointed out, you can have a great claim and you can have a very great enforcement chance or possibility, but our job is to get the assets, monetize them, and give the money back to the people that are appointing us. So a lot of our focus early is on where those assets are. Now, I think, like I mentioned, I'm going to go through a couple of examples, and these are based off genuine inquiries that have come to us and genuine cases that we've worked on. The point of this is to maybe highlight some of those factors I just mentioned. So the first one is a client that came, they had a very vanilla financing over receivables. They financed 90% of the receivables that were insured. They appointed a receiver over the receivables to collect, in their view, as much as they could, and then walk away and leave the rest of the company to the other creditors trying to collect their amounts. Once the receiver goes in there, which wasn't us in this case, they discover that all the receivables, or many of them, had been pledged to more than one financier. And all of a sudden, there were multiple parties trying to appoint receivers over lots of different receivers. They realised that, unfortunately, there was insurance issues because of alleged fraud, the company ends up in liquidation at the outset, and the liquidator looks to unwind some of these transactions and chase down the sponsors. At the outset, maybe some DD around that and around the different security package and the sponsor and some investigations might have pointed them in a different direction. In the end, it got to the right outcome. The second example I'll give is a company who had financed a listed entity. It had a trading arm and it also owned physical assets in Indonesia, Africa, and India. It had security over some of the listed shares and some of the shares in the subsidiaries, and then security directly over some assets, physical assets in various jurisdictions. They came to us asking if we could go as receivers over the shares in the listed company. After going through that discussion with them, we asked the same questions I mentioned before and said, that's great. What are you going to do once we're receivers? Ultimately, what we ended up doing was going receivers over there. We then at the same time went receivers over the shares in all of the subsidiaries. Of the subsidiaries as receivers, then we then appointed our own directors, ourselves and some other colleagues, as directors of the subsidiary companies. As directors of those subsidiary companies, we're then able to obtain all the books and records. We're able to image various servers, and we're able to take everything we needed for when the company ultimately went into liquidation. We had the information that we could then help facilitate insurance claims. So if we had have just gone in at the listed company, we may have given a bit of shock and awe to the sponsors, but we wouldn't have recovered any money. It was a combination of different appointments and ultimately forcing the company into liquidation that allowed us to take control and eventually make some recoveries. Not only the creditors that put us in, but for the general body of creditors. So, you know, that is really it from me. It was just trying to give some practical examples. For my main suggestion is spending a lot of time, you know, relatively speaking, up front rather than rushing in to make sure the appointments are done correctly. A lot of the time we spend an initial phase of work doing investigations with some of our trusted partners in different jurisdictions. We've recovered assets from houses, boats, cars, jets, watches. We had an interest in an English Premier League team. All of that was able because we were able to map the assets before we went in and then decided on the appropriate enforcement strategy, which really, you know, in Baldev's top 10 list, hit list, we used a lot of those to get in there and take control, sometimes gradually, sometimes quickly. So I will pass my time now across to Andrew.
Thank you very much. That was fascinating and really useful to listen to. And thank you to Baldev and Blackstone and Gold for hosting this seminar. Good evening, everybody, from an intermittently sunny and cloudy London, where we're currently in England recording around 20,000 cases of COVID a day. Just in case you want to play top trumps or statistical bettering one over the other with current daily rates in your countries, but I'm sure we're world beating at the minute in that regard. In the short time I have, my aim is to give you an overview of the pros and cons of the freezing injunction. Baldev's given an excellent introduction to the topic. I promise to give you 3 pros and 3 cons, but my overall aims are to make you aware of what a potentially awesome weapon the freezing injunction is, but also aware of its limitations and the responsibilities or burdens that come with getting a freezer. And most importantly, I think to share some practical tips. Now, in my section, I'm going to refer to the party seeking the freezer as the applicant and the party resisting it as the respondent. And I'm limited to speaking, of course, on the basis of my experience as an English qualified barrister, talking about English law and procedure, but I largely deal with cases, as Baldev mentioned, linked to the Far East, most often Singapore, mainland China, and Hong Kong. And I've been counsel on both sides of the freezing injunction game. And I most recently, with my highly distinguished colleague, Mr. Baldev Binder, successfully obtained a multi-million-dollar worldwide freezing injunction from the English court in support of a party in the Far East in its claims against another Asian party. Now, of course, I'm not going to talk about the specifics of any of my past cases today. My aim is, though, to give you practical insight of the pros and cons. So the structure, I'll start firstly with a relatively high level 8-point description of what a freezer is and the basic criteria. Baldev's largely gone over some key elements of that. Secondly, the promised 3 pros and 3 cons. Thirdly, I'm going to explore briefly the idea of a freezer being the nuclear weapon, the atomic bomb in litigation. So what is a freezing injunction? My 8-point run through. Firstly, as Baldev's touched on, a freezer is an order which prevents a party from using or disposing of their assets. So we say it freezes those assets at the time of the court order, and the hope is that those assets remain available to satisfy a future judgment. Well, that's one of the hopes. Number 2, the freezing of the assets is subject to certain permitted activities, so that the respondent can still do certain things, such as pay ordinary living expenses, ordinary business costs, legal fees, and even pay a third-party debt to a bona fide creditor when it falls due, because a freezer doesn't give you priority. Third point, a freezer can be obtained to support claims in the jurisdiction where you're getting it, and even foreign claims and claims in arbitration. The assets that can be frozen abroad, this is the 4th point. It could be bank accounts, shares, property, land, even crypto assets. There's a growing body of case law with freezing cryptocurrencies. 5th, the assets might be held directly by the respondent or by a third party, such as a bank. And Baldev rightly touched on that being a key consideration, because point number 6, the respondent and those with knowledge of the order, if they breach the order, they may ultimately be held in contempt of court. Now, ultimately in England, that can lead to 2 years in prison. So when you add that into the mix and you're a respondent at the receiving end of a freezing injunction, you might think very carefully about whether you want to run the risk of ending up in prison for 2 years. And many banks are very wary of breaching the orders once they have notice of them. Point number 7, the English courts can grant freezing injunctions regarding assets within the jurisdiction of England and Wales, but also overseas. And this latter type we call a worldwide freezing injunction. And this has made England an attractive jurisdiction for freezer applications, especially in significant fraud cases. We see a lot of oligarch Russian fraud cases in London with freezers involved. Number 8, the last point, in the right circumstances, one can obtain a freezer by applying to the court and having a hearing without the respondent even being made aware of the application, the grant of the order, or even the hearing. So you can get it, we call it ex parte, you get it sort of in secret, the follow-up responsibility being that you have to come back to the court pretty quickly afterwards with all the parties there. But the idea is if somebody's about to dispose of an asset and hide it, you want to get the freezer before they can do that. And you don't want to tell them that you're about to get the freezer. So what are the criteria then for getting a freezer? I've gone over sort of 8 characteristics of it. What are the criteria? So I'm going to highlight 4 and then tell you a little note at the end. The first criteria is a good arguable case. Now, practically, what you need to know is that to launch your freezer application, you've got to persuade a judge that you've got a good arguable case, which means you've got to prepare your case as if you're about to start your claim. Sometimes you're often required to undertake to commence your claim straight away. So that requires often quite a lot of work. You're preparing your claim as well as preparing the freezer all at the same time. Number 2, the existence of assets belonging to the respondent. You have to prove that there are assets belonging to the respondent, or that it's very likely that there are assets. Practically, we've gone over this slightly already, that can require research and intelligence gathering and the preparation of evidence to put before the court of those assets or the likelihood of there being assets. Third requirement, there's got to be a real risk that the respondent will dissipate his assets if the order is not given. Now, you've got to prove that quite carefully. It requires evidence and analysis and careful submission to the court that there is this real risk. And there are certain thresholds that you've got to get over. And finally, a kind of sweep up. The order's got to be just and convenient. So there's got to be justice in giving it. So if actually damages would save the day, you don't need the injunction, you probably won't get it. If you've delayed in applying, you might not get the freezer. So you have to act quickly. Now, I said there'd be a note after those 4 requirements for a freezer. And I've said it can be obtained without the respondent being told about or being at the hearing. Now, because the respondent's not there to defend the application, there's a very heavy duty on the applicant to provide full and frank disclosure to the court. And it shouldn't be underestimated, because you invest a lot of time, effort, and money getting the freezer. But if when you come back to court afterwards, the other side can show that you failed to tell the court everything, you failed to raise a particular defense that the other side would have run, you're at great risk of losing the freezer entirely for a breach of that duty. So it requires a lot of meticulous and careful preparation. That said, if the asset's about to be disposed of in 2 hours' time and you know it, you can, in certain circumstances, get an out-of-hours judge over the telephone to give you a freezer. I can see in the chat, I think somebody's asking if there's a PowerPoint. I'm trying to avoid having PowerPoints if possible, and tell you where I am in my talk by signposting. I do hope that's okay. Signposting further, the pros and cons. I said I would give you 3 pros and 3 cons. And I'm going to give them pro, con, pro, con. So pro number 1, a freezing injunction can preserve assets. That's really what you are wanting to do. You're wanting to stop things disappearing, going into the ether, so that you can't ultimately enforce a judgment against a particular party. If you're really afraid of the respondent dissipating its assets, then a freezer can stop that from happening, or is supposed to. Con number 1, we've said this already, it's top of my list. It does not give the respondent priority over other creditors. That's key in the discussion that we're having today. Pro number 2, it can be a knockout blow. Being on the receiving end of a freezer, not in all cases, but often in the right case, being on the receiving end of a freezing injunction can be a real shock, and it might lead to the respondent quickly paying you off, and you walk away. It could get you the quick knockout blow. Con number 2. When dealing with fraudsters, they can go to great lengths to resist enforcement. Sometimes obtaining the freezing injunction is just the start of a long battle you have to be prepared to fight and pay for. But again, if you're in a war of attrition, dealing with the claim and the freezer at the same time can wear the other side down even over a long battle. So they do have a role even in very, very tricky cases, because you've got the threat of contempt and prison ultimately hanging over the respondent or anybody in breach of the order. Pro number 3, I managed to turn con number 2 into pro there. Pro number 3, a standard freezing injunction wording requires disclosure of assets by the respondent. Now that can be worth its weight, more than its weight, in gold. The other side is required, at risk of breaching a court order if they don't, and contempt, to tell you about their assets. Now that can be very, very, very useful, not to be overlooked. Con number 3, the final great con, it comes with great burdens and risks and costs. As I said, you have to present all the facts and documents to the court. Get it wrong and you could have wasted your time and money. You have to give undertakings to pay damages to the respondent if it turns out you should not have got the order. And there could be liability to third parties, such as banks acting on the order. It takes a lot of preparation and hard work and input from various sources. It requires people to work together in often several jurisdictions quite intensively for a period. And I know one senior lawyer who has done a lot of freezing injunction applications, and unless it's a super urgent freezer, his general rule is, give me a month to prepare this if you want me to prepare it absolutely perfectly and get the order and not face any downside risks. A month can sound like a long time. Doesn't always have to be a month, but that's his rule of thumb. So my last section, I said that I would explore the idea of a freezer being the nuclear weapon, the atomic bomb. It's often called that. Now, I don't want to labor it too much, but in some ways it's not a bad analogy for you to take away from this. Let's think about how a nuclear bomb works. A well-delivered nuclear bomb can be dropped on the target without ultimately the victims seeing it coming, and without being able to get themselves or their assets out of the way. And they are sort of key elements of the freezer process. You can drop it before the assets have disappeared, and you can get it without the other side even knowing it's coming. So that's very similar to dropping an A-bomb. It can have, an atom bomb can have the effect of shock and awe and bring about conflict resolution pretty quickly when the other side realizes the power of what's just blown up. But I think if you think of any military strategy, any army around the world or military force, an A-bomb is part of their arsenal. It's not always to be used. It's expensive to have and to develop. And you also want to have your army and your navy and your air force and Luke and Baldev, other people who can explore the other options with you, not just dropping the A-bomb. And drawing out a couple of these parallels again, I don't want to labor it too much, but I do think it is a good way to keep this in mind. If you think about persuading any government to drop the A-bomb, they're going to be very reluctant to. Well, it's the same with a judge. Judges have to be really persuaded to drop it, to give a freezer. You have to dot every I, cross every T, and you have to prepare meticulously to do that. Think of the Manhattan Project, my next point, the Manhattan Project in the US to develop the first nuclear bomb. Think of how much time, secrecy, money, hard work, detailed, painstaking work went into it. It's often the same, preparing your freezer application for the first time. And third point, dropping the A-bomb probably isn't enough, sometimes isn't enough. You have to follow it up. You have to, be able to deliver it to the target. You have to be able to serve it. You have to tell other people about the threat of it, the banks. You have to follow up with the threat of enforcement, the contempt, sending somebody to prison eventually, to make it have teeth. So all of this comes with responsibility, just like holding the A-bomb does. You have to pay reparations if you get it wrong. So you have to give an undertaking to pay the other side damages if you should not have applied for the order. And finally, a point that Baldev made well, just as some states might not welcome foreign nukes in their own territory, foreign courts might not recognize or enforce your freezing injunction. And even the English court granting the order often or usually forbids enforcement or seeking to enforce that particular order in a foreign court without first satisfying the English court that that's an appropriate thing to do. So in short, in summary, it's a very, very powerful weapon which can kill a case relatively quickly, but you have to consider carefully whether you want to try to obtain it and deploy it. And if it doesn't work to get you quick resolution or settlement, or if you get it, but the other side don't crumble straight away, remember, it does not give you priority over other creditors. And that's the end of my section.
Excellent, Andrew. Thank you for that analogy. I like the A-bomb and the reparations and so on. I think that's quite apt. We've got some questions, and I think we can take them in the next 10 minutes. I have the easy task of just reading out the questions, and I'll point them to Luke and Andrew as appropriate. Let's start with the first question. This has to do with cryptocurrencies, which I honestly haven't applied my mind to. But for digital assets, particularly cryptocurrencies, where the ownership and transaction trails are masked and the only source of taking ownership is the passcode, how would a liquidator or receiver, or JM for that matter, trace such assets? Very good question. I would put my hand up and say I don't really have an answer to that, and I will direct it over to Luke in the first instance, and then after to Andrew.
Sure. Thanks, Baldev. I have some experience in this in Asian jurisdictions. I think cryptocurrency in particular has a little bit of mystique about it, but the reality is a lot of the exchanges now where crypto is bought and sold is done in regulated exchanges. So some of the big exchanges, Coinbase, Gemini, some of the ones that you will see in particularly the UK, Australia, the US, are regulated. So as a liquidator in particular, so I'll talk more about a liquidator than the others. A liquidator has the power to go to those exchanges, much like they have the power to go to a bank. And those exchanges have an obligation through KYC to see who owns and ultimately owns the whatever the relevant crypto is on their exchange. So that would be the case for regulated exchanges. If you have a somewhat more sophisticated counterpart who knows that and hasn't bought their crypto on these exchanges and on some less regulated exchanges in different jurisdictions, including some of the exchanges in Singapore, this would come down to more heavy lifting. So some of the ways we would do that would be through forensic imaging of computer equipment. Ultimately, people tend to write their codes down, and yes, they are in large, long, sometimes unintelligible codes. But if they're stored somewhere, there are various ways to store them. People have offline hardware wallets which are not connected to anything. If you find that wallet, great. But often there is two-factor identification, very hard to get into. So it's not perfect, but the human ultimately becomes a personal game rather than a technology game in that case, because people will write and store these somewhere in a physical location. So it'll be working with our forensic partners to do very deep searches through lots of information, trying to find things that look like keys, and then throughout the various exchanges, all of the crypto that's traded, or most of the crypto, with a few exceptions, are public. So again, there are some very good people out there to help in this tracing. But the first point would be looking for regulated exchanges and seeing if the assets are held on those exchanges. Pass over to Andrew if you have anything else to add.
Yes. There have been some recent cases in England where the courts have decided that crypto assets or cryptocurrency isn't a shows in action. It is actually property for the purpose of a freezer. And again, if you get a freezer in relation to a respondent, which identifies their cryptocurrency assets, it works in just the same way as telling them that they can't get rid of their cash, they can't empty their bank account. And also, of course, as Luke mentioned, a lot of these assets are now in exchanges. So you can also serve on somebody essentially holding the cryptocurrency for the respondent.
Great. Andrew, another question for you. When you have investigators deployed before you launch your freezing injunction, for example, you get an investigatory report saying where the assets are, who the different parties are, how are they linked, who's related to which party. Is there any restrictions or issues with using such a report in court, bearing in mind data protection considerations?
That's a big question. Rule number one is obtain information by lawful means. In essence, with the test of things being just and convenient and full and frank disclosure and so on, you don't want to run the risk of impropriety in some way that taints the way in which you obtained the freezer. In terms of, in many ways, I've not had to deal with the GDPR practices of investigators. Maybe I should add that to my bedside reading list. But essentially, the advice I always give is just get it lawfully and write it up as well as you can in a report, in an affidavit, to establish that there are assets. I mean, there are recent cases where parties have not even been able to pinpoint assets. But they've been able to establish that there's a really strong likelihood that there are assets. It's just that we can't tell the court yet what those assets are, and it's for the other side then to disclose the assets. But if you can establish that there are assets, then that there's a likelihood of there being assets, you take the pressure off your investigators, essentially. But you do need to have made efforts to try and find out and to explain to the court why it is that you can't find the exact assets, but why it's very likely. Maybe you've just paid them $100 million. Maybe, they've been swanning around on a yacht. Whatever the case may be. But in terms of GDPR practices and data protection, I have to hold my hands up and say that's something I advise on at a very high level.
Understood. There's another question that's come through, and I would dare to take the answer for this. And the question relates to, essentially, if I'm reading it right, would be when, in a liquidation scenario, when do assets go into the general pool for the body of creditors, or when can it be said to be secured for a specific creditor? And the example given was in specifically with receivables financing. So when a financer finances an invoice, for example, that receivable due, when does it fall within the general assets of the company, and when is it outside of that? I think without there's one way of looking at this, and it's really a question of whether you are a secured or unsecured creditor. Where there is a charge, for example, where there's a fixed charge on a fixed asset, then that charge has been crystallized properly and it's been established, then the creditor then becomes a secured creditor. So it's that asset is carved out from the general pool of assets, and that's secured, earmarked for the secured creditor in the liquidation. Assignments can be assignment by way of security, can be assignments by way of outright sale as well. So in receivables financing, for example, for most part, you are actually selling the invoice to somebody else. So that actually creates, on one hand, a security. On the other hand, that might actually be a fresh asset outside of the pool of the assets of the company. So that's to answer that question. If anybody else has any other questions, please feel free. It's not often we get Andrew's free input. Okay, I don't think there are any more questions. Feel free to drop me any questions along the way after the webinar, and we'll be happy to answer it collectively. I would like to thank my guests, both Andrew Stevens and Luke Fuller, for the candid discussion on the different appointments and the considerations for it. I think the passing or the ending comment, really, the ending view about this is that a lot of homework needs to be done. A lot of consideration needs to be given at the start, not when you've launched in. A lot of effort, a lot of thinking needs to go through. If you're appointing a receiver, you need to think through what happens after you appoint a receiver. If you're looking to obtain a freezing injunction, apart from all the steps of obtaining a freezing injunction, you then got to think about the next steps of what happens after the freezing injunction. For a liquidation and a judicial management, I think that tends to be somewhat discrete by itself, because it tends to be putting the company into a different state of affairs and letting a third party then sort out the affairs of the company and divide up the assets to each creditor. So each path, I think, has got different considerations. Time, money, effort put into it, all of it weighs up. It must be borne in mind. I'm just having a quick look to see if there's any more questions. No, I think that is it. So we've come to the end of an hour. I'd like to thank the audience for taking part in this webinar and hearing our views. And of course, to my guests once again, both Andrew and Luke. Thank you, gentlemen. Have a good day, everyone.
Thank you.
Thanks, Baldev.